also want to thank everyone for having me here. It's a pleasure and a great opportunity to be here before you today. As Stephen noted, I've also handled some real estate cases, and in addition, this topic is of particular interest for me since I've also personally invested in tax liens here in Orleans Parish. In addition, I've also done some work on behalf of Archon, which, as many of you know, is the leading company statewide in handling the administration of the online tax sales for parishes across the state. Now, just by show of hands here, how many people are attorneys? Okay. And I see that, I presume that the vast majority of you have invested in Louisiana. Anyone invest in other states' tax liens? Okay. Now, when I first was asked to speak, I thought it was a rather unusual confluence of topics. Basically, antitrust is primarily a matter of federal law. You generally hear of it being enforced by the Department of Justice out of Washington, D.C. Tax deeds, however, are at the municipal level. As Tom said a few minutes ago, he said it's incredibly, incredibly local. And I thought to myself, how do these fit together? Did a little bit more digging, a little bit more thinking about it, and there have been some cases, both in the criminal and civil arenas, that have drawn attention to the antitrust implications of tax liens, particularly in an auction setting. Now, I'm not aware of any cases that have arisen in Louisiana, but that's not to say that it cannot happen here. What I want to do today is to give you an overview of antitrust law this morning, the 30,000-foot view, just given the time constraints. We'll be focusing primarily on federal law, but just give you a quick rundown of how Louisiana law compares as well, and then apply it to the tax lien context. There's been some important differences between the structure of Louisiana's tax sale proceedings and those from other jurisdictions, particularly Illinois and New Jersey, where they've had some issues over the years. I think it's a lot less likely to happen here just based off of the incentives that are built into the structure just from a legal standpoint. But at the same time, it's important for us to figure out what problems arose under the Illinois systems, the New Jersey systems, and see what opportunities may exist that could be exploited under Louisiana law, what the potential is for anti-competitive collusive activity, and to make sure that you know the scope of the ramifications of that. Now, when I talk about antitrust, you might think of the robber barons of the 19th century, you might think of the monopoly man, you might think of Standard Oil from 100 years ago, AT&T being broken up into the baby bells in the 1980s, or even more recently, the Department of Justice going after Microsoft. And against that backdrop, you might ask yourself, what does this have to do with tax liens? Well, what we do is we should start by looking at the operative federal statute, and then we can see how they've been applied in practice to the tax lien industry. So the beginning point is the Sherman Antitrust Act. It was enacted originally in 1890. It still remains the centerpiece of federal law, antitrust law, and it remains largely in its original form. The focus of the Sherman Act is on protecting the consumer by prohibiting anti-competitive activity. Of course, that begs the question of what is anti-competitive activity. What one person may say is anti-competitive, the practitioner of it may say it's simply an economically rational response to circumstances and market trends. So let's focus on the language of the statute. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony and on conviction thereof punished by fine not exceeding $100 million if a corporation or if any other person $1 million or by imprisonment not exceeding 10 years or by both said punishments in the discretion of the court. So there's a couple of pressure points in the language that I just want to highlight for you. The first is among the several states. What gives it federal jurisdiction is the fact that it is interstate. There's got to be an interstate component. And you might think in the tax lien world, well, how does this apply? All the properties are local, the investors are generally local. But remember when we asked if there's people who invest in other states? The flip side is true. People from other states often invest in Louisiana. You'll also see in some of the cases that I'm discussing, you've got companies from all across the country. that may invest in a local property sale. And in my personal experience, I've invested in tax liens with my father, who's in Michigan. We formed an LLC. Our involvement is technically interstate commerce. And that would be the same even if there were 30 members in Louisiana and just one in Michigan. Alternatively, conduct can give rise to the interstate character of it. For instance, even if you're just out on your own participating in the Orleans Parish auction, but you're out of town at the time, you log onto your computer from California and do your bidding there. That's also interstate. Next language I'd like to focus on is the in restraint of trade or commerce. That language is very broad, and the number of potential anti-competitive activities, it's too broad to list. I would run out of time just running through the list without explaining them all. What I want to do is focus on two broad categories under antitrust law. Restraints of trade or commerce, there's basically two types, two ways that the courts analyze it. Per se violations and the rule of reason. Generally, most potential restraints on trade are analyzed under the rule of reason, which basically it's a fact-specific inquiry based on the reasonability of the company's conduct. It's a very fact-specific inquiry. You have to look at the operations of the company, the relevant market, the specific nature of the restraint, and the actual or intended effects. In the tax lien context, however, the ones that are the most relevant are what are called per se violations. If you've done what's classified as a per se violation, there's no economic justification for it. There's no explanation that, oh, well, there's other benefits for it. The primary examples of those types of conduct are price fixing, market allocation, and bid rigging. And the latter two are particularly applicable in the tax lien context. For instance, market allocation is where two or more competitors divvy up a particular market. It's not limited to an auction setting. It can happen in any type of industry. But for instance, if there was, in the tax lien world, for instance, if there were three competitors, I said, okay, I'm going to focus on New Orleans East, you focus on the West Bank, you focus on Mid-City, and we agree not only that we're going to have our base of operations there, but we're not going to interfere with each other's efforts to bid on properties. The coordination of that is what makes it an allocated market in that sense. And then bid rigging commonly occurs, obviously, in a bid format, usually either in an auction or if there's a request for proposals to be submitted, such as with a public works contractor submitting bids. In that instance, you'll see parties agreeing in advance to take some sort of concerted or coordinated action to ensure that they can maximize their benefit on one project, the other guy gets to maximize his benefit on the other project. In effect, you scratch my back, I'll scratch yours. The cases that I'm going to discuss in a couple minutes demonstrate this principle in the tax lien context. Basically, some market participants are going to say, we're not going to bid on these properties, and you agree you're not going to bid on the ones we're interested in. The end result in that situation, where bid rigging, it's to maximize the expected return for the participants, often at the expense of the property owner or the general public. Sometimes bid rigging can take on a more elaborate character. For instance, if they're trying to think, well, we can't be too obvious about it, we have to try and avoid detection. For instance, in a request for proposals situation, you might say, well, we can't have only one proposal be submitted for all these projects, so you might have sort of dummy proposals submitted that don't meet the parameters. So on the surface, there might be 2 or 3 people submitting proposals, but there's really only one legitimate one, and that one is at an inflated price. Now, those are some of the per se violations. Not all antitrust concerns, as I said, are per se. You could also have, with respect to service providers in the industry, for instance, that if they're accused of an antitrust violation, it's not really our focus today. Our focus is more on from the investment standpoint. There's generally nothing that's unique to the service provider standpoint, so I'm not going to focus on that today. In general, the rule of reason is far more deferential to the defendant. If you find yourself accused of an antitrust violation, you're going to try and do everything possible to argue it should be analyzed under the rule of reason framework rather than the per se framework. Okay, let's talk about the penalties that are available under federal law. From a criminal standpoint, as we discussed, the language says that there's up to $100 million penalty, which is on a sliding scale. Not everyone is going to get the complete penalty. Generally, they look at factors such as the amount at issue. There's also various aggravating or mitigating factors. For instance, if you cooperate with the investigation, they're going to be more lenient on you. Civil remedies, the people who are harmed by the scheme can recover treble damages and attorney's fees and costs. Together, this should create a very strong disincentive to engage in collusive and anti-competitive activity. Now, I spoke earlier about Louisiana antitrust law. The scope as far as what is prohibited is very similar to federal law. There's three primary differences. The first is that Louisiana applies only to conduct within the state. The Louisiana state law does not address interstate conduct. It's supplanted by the federal law in that regard. Secondly, the penalty scheme under Louisiana law is comparatively toothless. As compared to the $100 million and 10 years, it's $5,000 fine or 3 years imprisonment. I'm not quite sure why the Louisiana legislature thinks that those two are in any way equivalent, but that's one of the many mysteries of Louisiana law. And then finally, Louisiana law also expressly provides for the liability of corporate officers. It provides when a corporation violates any of the penal provisions of this part, the violation shall also be that of the individual officers, directors, or agents of the corporation who authorized, ordered, or did any of the acts constituting in whole or in part a violation. They're subject to the same penalties as the company. There's much less jurisprudence interpreting the Louisiana law as compared to federal law, in part because the vast majority of conduct has some sort of interstate component. Also, the federal judiciary is generally better equipped to handle complex antitrust cases as well. You very rarely see an opinion from a state court dealing with antitrust law from a Louisiana court. Now, let's focus on the tax lien auctions and specifically how antitrust can arise. I'm going to talk about situations that have arisen in Illinois and New Jersey. They're both similar in their framework, but it's a little bit different from how we do it here. In each instance, both of those states have a reverse auction, which starts off at a maximum interest rate of 18%. You bid downwards, down as far as 0%. The principal amount stays the same. Now, if the winning rate is high, then the homeowner is going to have to pay that much more to redeem the property. Think that this probably creates some skewed incentives. The theory behind this type of setup is that over time, the rates of the winning bids will equalize around where a low-risk investment, such as municipal bonds, would end up, and that the owners would be able to redeem the property at a manageable price. Let's see how that plays out in practice. So I'm going to first talk about an Illinois case that arose in the mid-1990s, the Alexander case. It had an open outcry auction, what you think of with everyone raising the cards, going, gone, the descending bid system. One of the features of Illinois law is that the auctioneer is not going to seek out a lower bid if there's multiple parties that are interested at a set price. Instead, he'll select the winning bidder in a fashion to try and avoid one party getting a disproportionate number of the properties. He's going to try and basically spread it around. So beginning in 1994, one company, which was one of the leading players in the field, saw an opportunity. And what did they do? They started registering multiple bidders to exploit this loophole, figuring that we'd have a better chance of winning on the ties. So everyone responded to that the next year and brought multiple bidders of their own. It's basically just a tit-for-tat strategy. You recognize what they're doing, do the same, throw it right back at them, and they're back at square one. Now in 1996, or I should say the sale from the taxes that were due in 1996, the sale itself occurred in 1998, there was a substantial change in the bidding patterns. Hopefully, I don't know if y'all can make out the chart, but basically the average winning bid from the 1980s roughly was around 10%. Beginning from 1992 to 1995, it dropped sharply to about 2 to 4%. The most common winning bid in the 92 to 95 tax sales was 0%. A majority of the time it was basically they would bid 0% and just bid a small premium above that. What happened in 1996? The average winning bid jumped from 2.1% to 15.7%. The most common winning bid was the maximum, 18%. Almost 4 out of 5 properties went for the maximum. And it's actually even worse than that. What happened was the auction occurred over a 3-week period. 8 days in, there were 95% of the properties going for the maximum. Auctioneer decided we're going to have to change the rules midstream and basically said that if there were multiple simultaneous bids, then none of them would be accepted and they'd have to bid at a lower rate. 4 of the major players in the industry objected. They ran out to court, sought a temporary restraining order prohibiting them from implementing that rule change. As soon as it went back, everyone was bidding 18% and 18% only. They had a run of over 500 properties in the auction that were at the maximum rate with nothing below that. Another way of looking at it is to see how many runs of 10 properties in a row where it was the maximum rate. In 1995, they only had 3 runs of 10 properties in a row at the maximum rate. They had 426 runs for the 1996 sale at that rate. So as a result of that, there were class action lawsuits filed. The plaintiffs, who were the owners of the properties, alleged a broad conspiracy among a group of 18 tax deed purchasers who were basically the major players in the market. They alleged that they were forced to pay substantially higher redemption rates than would have existed in a competitive market. If using the data from a year before, the average rate would have been 2%. Instead, they were paying on average almost 16%, and most of them 18%. A class was certified by the federal court, which basically said, we believe that all these plaintiffs are similarly situated. It's much more efficient to handle their claims collectively as in a group rather than on an individual basis. They didn't have any direct evidence of a conspiracy, but there was a whole lot of circumstantial evidence just based on the numbers. Now, what the defendants argued is that there was no organized conspiracy, but instead they were engaged in what they called parallel pricing behavior. In effect, they were playing follow the leader. It's kind of an offshoot of game theory, again, the tit for tat theory. And if one player engages in that strategy, the other players will then fall in line and adopt the same strategy to try and reduce the competitive advantage from the first mover. The court referred to the theory of conscious parallelism, which they said, quote, applied to highly concentrated markets where few sellers exist and where they establish their prices not by express agreement, but rather in a consciously parallel fashion. In effect, they're just trying to pattern it after the market leaders and first movers, but again, they're saying we didn't have any sort of conscious agreement, there's no smoking gun, there's no agreement, nothing written, and we were simply just acting as rational economic actors in a chaotic environment. One thing I thought that was interesting from that argument, they treated it as a relatively closed marketplace with a, quote, highly concentrated market. Yet there's no real barriers to entry for the auction setting, and it's not apparent to me from the analysis of the case why there were so few parties willing to participate in the auction as a whole. The court tested the defense for each of the defendants based off of what they called plus factors. In effect, they said, we don't have the direct evidence of it, but so they didn't treat it under the per se violation. They instead went through on a defendant by defendant standpoint. The defendants had filed motions for summary judgment saying, look, you have no concrete evidence, it's all circumstantial, let us out of the case. The court said, let's look at whether there's any behavioral indications which these plus factors might suggest a conspiracy even in the absence of direct proof. Each defendant has to stand or fall on his own merits. It's not an all or nothing proposition. The court ultimately held that there were plus factors that suggested a conspiracy among some defendants but not others. There was too many defendants and too little time for me to go through them on a one-by-one basis, but I want to go over the types of factors that they highlighted for some of the specific defendants. In particular, they emphasized meetings and communications between the various defendants, particularly those that occurred relatively close in time to the auction. Also, the decision to reduce their number of bidders prior to the sale. It's one thing if you say that we're reacting to the market, but if you're making the decision even before the market trends manifest themselves, it appears that they thought that it was more likely that it was a concentrated effort, a joint effort to basically have a mutual non-aggression pact in that sense. For one party, they cited that its agent created a new entity solely for the purpose of participating in the bidding in that sale, even though the market was at its lowest point from the prior 15 years that year. The company that created that entity was the single biggest player in the market. It was surely aware of the low rates. The court thought that it was possible that they were planning to exploit that market, and it wasn't merely coincidental. And so they said that that party had to stay in the suit. It also looked at the very first bids made by each party, suggesting that if you bid 18% right out of the gate, that reflects a conscious pre-auction determination rather than a reaction to the trends that have been established. Now, a couple of the companies were actually able to get out at summary judgment, and the factors that the court cited there were two small companies that had linkages only to each other. They were not able to establish that they had any connection to the others, and the court noted that they were too small to affect the overall market. With no linkage to any of the parties, there was no basis to suggest that they had caused any sort of restraint on trade. Another party was a late entrant to the market. Basically, the auction went on for a period of about 2 to 3 weeks. That defendant didn't even register until 4 days in. It didn't make its first bid until 10 days later. By that point, the market trends were clearly established. The court held that bidding 18% was already an ingrained course of behavior. Illinois has not changed its system since that time, and in fact we've seen more recently another case that has arisen involving a county treasurer in Madison County, which is in the southern portion of the state close to St. Louis. Basically, he was rigging bids and in effect trading it for campaign contributions. And true, yes, 4 people pled guilty as a result of that. I didn't focus on that case as much because they pled guilty. There are no written court opinions. I thought the opinion in the Alexander case did a very good job of laying out the data and the trends over time and the sorts of factors that the courts look for in finding some parties liable and other parties not liable. But nonetheless, that recent Illinois case certainly should let you know that this concern is still ongoing. The bids, just in one relatively rural county, the bid rigging there was in excess of, I believe, $1 to $2 million. The campaign contributions, needless to say, were nowhere near that amount. Also wanted to focus on another state that's known for its good governance and high standards of ethics, along with Illinois and Louisiana. In New Jersey, there was a major investigation involving tax lien practices over the course of a decade, beginning in 1998. New Jersey has a similar scheme to Illinois with the downward bidding, beginning at 18%. Again, if it reaches 0%, they'd have to bid an additional amount in order to obtain the lien. They don't have the Illinois tiebreaker system of, okay, you haven't gotten one in a while, so I'm going to give this to you. That's the only real difference between the New Jersey and the Illinois systems, at least as of the times of these cases. In the New Jersey case, the feds had claimed that a group of investors had conspired to allocate the liens. They refrained from bidding on liens that were allocated to other participants. They even had little black books that basically said, this property is yours, this is mine, and basically laid out who would get what. Now, it's a little bit different from an administrative standpoint. New Jersey has 566 municipalities which each conduct their own auction. Illinois does it on a county-wide scale. So the Cook County auction would get 27,000, 28,000 properties a year. Some of the municipalities in New Jersey are very small and may only have a couple, and that may have also helped some of the parties go on year in, year out while avoiding detection. It's less of an opportunity, probably directed less public attention. As a result of the indictments, there were 14 guilty pleas consisting of investors, companies, and executives in those companies. And also as part of the plan in New Jersey, if someone deviated from the plan as far as trying to bid against a property that was allocated to someone else, they would basically enforce discipline by going after the properties that were allocated to the party that was going against the plan. The court also noted that they engaged in old-fashioned threats and intimidation. I'm shocked that this occurred in the homeland of Tony Soprano. So, there were multiple motions to dismiss the charges filed in the New Jersey case. Basically, there were class actions that were filed by various investors and then consolidated in a single proceeding. The defendants, as often is the case in a antitrust case, file what's called a motion to dismiss, basically saying that the pleadings are insubstantial on their face. They did not adequately allege the conspiracy. The judge initially threw them out and said, plaintiffs, please replead them with more particularity. They went back, defendants refiled their motions to dismiss, and then they were analyzed as a per se violation of bid rigging. Ultimately, the court held that the plaintiff's claims were sufficiently detailed to constitute a Section 1 violation. They emphasized that they listed the dates, the locations of the instances of collusion, and identities of the parties. That was sufficient to withstand the motion to dismiss. So what happened? Everyone settled shortly thereafter. According to the settlement agreements that were filed with the court, around Christmas time of 2014, there were 4 defendant groups totaling 17 defendants that settled for about $6.8 million. They also agreed to take a 15% reduction in the redemption value. There were 2 other groups of defendants, one that settled before that, one that settled after that. The first group had settled for about $955,000. The second group, the most recent ones to settle, which was, I believe, just this past March, settled for a little over $1.25 million and also took the 15% discount. Also, one thing that was, I thought, interesting in the decision was that in the decision on the motion to dismiss, the court was going through the allegations against each defendant separately, and for a couple of them, it noted that they were members and participated in meetings of a trade industry group. It emphasized that their involvement was, quote, not definitive evidence of conspiracy, but nonetheless, quote, lends support to plaintiffs' allegations of collusion. In effect, it held that their participation in that group was suggestive of opportunity. It was not proof, and at the motion to dismiss stage, they're not looking for proof necessarily. They're just asking, the court is asking, does this state a facially valid claim? And the court thought that that was a mark in that favor, without deciding one way or the other as far as any activities that they did in connection with that trade industry group. Now, against that backdrop, I'd like to discuss for a minute, how does this compare to Louisiana? I mean, obviously, we do not have that the bid down on interest system. Our system is different, and it's an entirely fair question. I think that based off my review of these cases and the framework of Louisiana law, we are probably less susceptible than Illinois and New Jersey to have this type of collusion arise. I think there's 2 main reasons. One is substantive, the other is structural. First, the bidding by a reduced interest in the property as compared to a reduced interest rate. The redemption price is not affected by that. So I think there's a little bit less of an economic incentive for collusive activity under the Louisiana system. Secondly, the online system, I think, creates a completely different dynamic that does not lend itself well to collusion. If you're in an open live auction, you know who's bidding. You can see them, you can read their body language, and you know the universe. People who are not in the room are not bidding. It's more of a mystery in an online setting. There's also much less of a chance to, in effect, punish defectors as you would have if there was a collusion in a live auction where hey, they bid against me, I'm going to now go after them and try and cut them down on the properties that were allocated to them. I think there's much less of an opportunity under the Louisiana system to punish defectors and enforce any sort of collusive pact. The catch, I do think there's some potential regarding adjudicated properties with the bidding on that, but again, the online nature of those auctions still, I think, makes it less likely to occur under Louisiana's system. Finally, I'd like to close just with a few general words of wisdom and a general sense of what not to do. Antitrust litigation is incredibly expensive. It's incredibly time-consuming. If you're caught up in it, they're going to try and subpoena or use discovery to get all your emails, all your private communications, and basically expose the inner workings of your investments. No one wants that. They certainly don't want to have to pay lawyers for the time that's necessary to defend you against that. So try to avoid engaging in activities that will avoid suspicion. First, do not discuss bidding strategies or policies with competitors. That's the hallmark of collusive activity, particularly in the tax lien context, a bid rigging scenario. If you do end up having to meet with them, make sure that there's a clear agenda saying we're going to discuss this. We are not going to discuss the bidding for the auction that's coming up in a month. Just make clear what is and is not on the table, and make sure that the meeting has a legitimate business purpose. Also, the timing of the meeting matters from a court standpoint. The court is likely going to pay greater attention to a meeting that occurs, say, 3 days before the start of the auction as compared to a meeting that's 6 months before. That one might be a little bit more innocuous. Don't agree to any sort of quid pro quo with respect to the bidding or allocation of properties. That's, again, the hallmark of a per se violation. There's no benefit whatsoever from an economic standpoint to that type of activity. It likely is going to be treated as a per se violation and will be difficult and costly to extricate yourself from. And finally, if you think it may sound fishy, any sort of proposition that a competitor raises, or even if it's an idea, listen to the little voice in your head. Exercise caution. A little bit of discretion in that arena will go a long way. If you have further thoughts, please, it's best to contact your attorney rather than run the risk of a costly and counterproductive antitrust investigation. Thank you very much.
All right, does anyone have any questions for Mr. Kessler?
No. Yeah, I do. Yes.
What if the collusion is unwitting?
Is on winning?
Yes. In other words, they didn't know they were colluding, but they were colluding.
Oh, unwitting.
Yeah.
Well, I believe there's. I guess, could you give me an example of how they didn't know?
In Florida, they have it's called the Fast Five.
Okay.
You can bid down to a quarter point, and at the discretion of the person conducting the sale, they will arbitrarily assign, okay, you get this one, you get this one. Well, I think this is a scheme. One year, this group came in, and if you've seen the dynamics of the most tax collectors, they're middle-aged men that are secure in their positions. Well, this one group came in, and they brought in 16 people to bid. They were between 18 and 25, and they were all wearing cheerleader outfits. And so, and they had signs saying quarter point, quarter point, quarter point. And unwittingly, they got the vast majority of all the liens. So they monopolized that market there. But did they do it? Would you consider that collusion?
They were all within the same investment group?
Oh, yes.
Yeah. You cannot collude with yourself, in effect.
Okay.
Yes.
So what they did wasn't illegal?
No. Clever, but not illegal. Yes.
Yeah.
A more perhaps innocuous example of a couple of people who both bid, and they've got their list of properties they want. They just sort of say, I wanted this one, and there's really no. It's more of a favor rather than a quid pro quo. It's like, well, I want this one, or this was my mother's sister's house, and so I really want to keep it in the family and things like that. And if there's no real profit, plus in New Orleans especially, you've got 30, 50, 100 other people who are bidding against you. So my agreement not to bid on a property you want, and you not agreeing to bid on what I want, does not necessarily give either as an actual advantage, even though it does sound like it would be collusion.
Right. In general, just from an enforcement standpoint, it's difficult for them to treat a single property as indicative of anything. In the cases we've seen, it's generally been long-term operations involving thousands of properties. Another component of it is the enforcement of discipline against defectors to the agreement. And in the scenario you proposed, that doesn't really sound like it. Like there's any component to that, where if you bid against my mother's house, I'm going to bid against these 3 properties.
So the retaliation or enforcement
The retaliation is generally a very strong point in favor of suggesting that there is an improper purpose and that it is in fact collusive. Also, generally, a single property or 2 generally won't affect the market in the same way that a systematic agreement would. Any further questions? Thank you very much. Appreciate it.